we deal with families. We deal with people. We're not doing a lot of business clients. We're not doing a lot of sophisticated transactions. We're dealing with everyday people in real life situations. And because we've been doing that for so long on the divorce side, we have an ability to do that on the estate planning side better than most firms. And that's because we have a certain expertise in that.
Welcome to Life's Third Act, an enlightening look at estate planning, retirement, and beyond.
Welcome to another episode of Life's Third Act. Joe Cordell's not here today, and my name is John Sauter. I'm a senior estate planning attorney at Cordell. What we're going to talk about today is powers of attorney. We've been talking about, for the last couple episodes, the most common questions people have in regards to estate planning. Everything we've talked about up to this point has been what happens if you're no longer here, which is what most people think of when they think of estate planning. We've talked about trusts, we've talked about wills, but today we're going to talk about something a little different. We're going to talk about what happens when you're alive but unable to act, right? What in that situation, most of the time we're talking about powers of attorney, okay? And just to break this down a little bit so you can understand this concept, the first thing is when could I not act, right? That might be a question that's coming up. The most common time you can't act is usually health related, right? If you aren't able to make decisions on your behalf, which can be a wide range in and of itself. That could be from having dementia to being in the hospital for a surgery, maybe being out of the country. Sometimes if you're going to leave for a long period of time, really we're talking about any time that you're not able to manage your life and your property and you need somebody else to step in.
That's what I've never thought of before. And I'm sure probably a lot of people, like just not being in the country is...
Right. Another common one is prison, right? When you're in prison, you can't manage your own property. Now, nobody expects to go to prison, and yet they're full in every state. And so what we're talking about here is trying to make sure that you have a plan. And that's what we're really concerned about at Cordell, is making sure that any of life's unexpected events you've got a plan for, right? And if you're with Cordell, the unexpected becomes expected, right? And we're going to put a plan in place that will cover everything. And so a part of these packages we put together that include wills and trusts is going to include a power of attorney. And so the first question is, of course, what is a power of attorney, right?
This is a really elementary question, but one I don't think it's sad because I've been recording so many of these episodes. I should know certain things.
Don't do that to yourself, Justin.
But I always hear the difference between power of attorney and powers of attorney. Is there an actual difference? Or are they interchangeable?
Powers of attorney just being that there's multiple, right? So in that sense, when we're talking about a power of attorney, we're talking about naming someone to be able to make decisions on your behalf, okay? And the truth is those decisions can vary widely. You could want just financial decisions, who's going to manage my assets? But there's also a different set of decisions that need to be made if you need medical care, right? And so when we're producing powers of attorney, we're producing a financial power of attorney and a healthcare power of attorney. And so when you're referring to the specific document or sometimes the person, this is another thing that comes up. What do I call the person that is my power of attorney? Because it's really confusing. It's like they're signing, what are they going to sign as? Okay. John Sauter, power of attorney for, or you'll see attorney in fact, right? Same thing. Agent, right? All of these things really refer to the same thing. You're acting on somebody's behalf. Actually, you're bringing up another interesting question in my mind. Why all these different terms, right? When we're talking about somebody acting on your behalf, they're always your agent. That's the most simplest form, right? But for us, it's kind of like doctors when they talk about prescribing and analyzing what's wrong with somebody. They're going to give a word that's going to describe a set of symptoms, right? And when we're talking about agents in different documents, when I use the word attorney in fact or trustee or personal representative, by doing that, I'm signaling as to what document I'm talking about. Right? So when I say this person is the attorney in fact or power of attorney, we know we're talking about a power of attorney document. If I say this person is the trustee, we know we're talking about a trust. Essentially, they're all agents, but we're referring back to specific powers, specific situations, and moreover, specific documents.
Really, it's more of just a pure grammatical thing of
It is.
talking about this specific thing or this group of things.
Right. It helps us be clearer, right? And I think that's the big challenge in all planning is how clear can I make this? Because when I'm writing something, I'm always thinking about how it's going to be read. Who's my audience, And I tell my clients all the time, when we're creating an estate plan, I've got two general audiences I'm thinking about. One is, of course, the client. Right? I want you to feel secure in your plan. I want the plan to reflect your wishes. And I want you to understand it so you can best implement it. But I also have to be thinking about the person I'm representing is not going to be the agent. They're not going to be the person implementing the plan. And so if I am not clear in my direction, I'm making it much more difficult for that agent to do their job. And so a lot of times, a large chunk of what the time that it takes for me to write a plan is writing it once, coming back, rewriting it, and just trying to first remove as much legalese as I can, right? Because that might serve me and the other attorneys I'm talking to. But when we're talking about these agents, right, these powers of attorney, the people that are going to step up and act on your behalf, we're talking about regular individuals, right? That don't know any of this, that don't have a background on it, that don't understand. And as clear as I can be, that's going to avoid issues when they're trying to implement these documents.
That's actually a good point that I thought about a while ago in regards to your document, your estate plan specifically, or your power of attorney document. They're probably the most common legal document that most average people would see. Would you agree with that?
Yeah, other than like the agreement that you click through and say, I agree, that nobody reads, right?
This is true.
Leases.
The EULAs that you sign every single day of your life.
Yeah, right. I'd say leases are really common. When you think about, I a lot of times think about when do people interact with attorneys in these documents, right? And I have to be really reticent of this when people walk in my door and meet with me because, like estate planning, most of what you understand about attorneys comes from TV and movies, right? If you've been lucky, right? There's a chance that you've run into some attorneys and hopefully that's been a good experience for you. But in the aggregate, it hasn't been, right? And so when people are walking in my door to do estate planning, I think there's a certain kind of nervousness that I have to address because they're meeting with an attorney and it might be the first time they're meeting with an attorney and they don't know what's going to be on the other side. Is this the prosecutorial type that's going to be really, pushing me and not as friendly? Is this going to, what person am I dealing with? And so the first part is to understand their understanding of attorneys and kind of teach them what my role is going to be, right?
We talk about that a lot too with, on the other side of Cordell and Cordell's business. If someone's getting a divorce, a lot of times that's the first time they've ever interacted with an attorney ever.
Yeah.
But that's a little less sometimes purposeful, whereas when you're getting an estate plan done, where you're getting power of attorney documents made, it's usually you that's the one that's going on purpose to get something done. So hopefully that eases the tension a little bit, but I still can understand, like, anytime you're going to, like, even doctors, sometimes there's a little bit of nervousness there.
Oh, definitely. I'm nervous around the doctor, right? I don't know how they're interpreting it or what they're thinking. It's I'm always really reticent also of the notepad, right? Because if somebody's talking and I'm, oh, really? Okay. And you write down, and they always, what is he writing on there, right?
Hopefully it's not, this patient is ridiculously difficult.
Right. And so, I don't take as many notes as I did early on because I think it makes people nervous, right? What are they writing down? Who's going to see that? All that kind of stuff. And so we're trying to break that down in that first meeting and build a relationship. And I think for Cordell, we talk a lot about this seemed like a no-brainer to move into estate planning. And what Justin just brought up is why is it such a no-brainer is because we deal with families. We deal with people. We're not doing a lot of business clients. We're not doing a lot of sophisticated transactions. We're dealing with everyday people in real life situations. And because we've been doing that for so long on the divorce side, we have an ability to do that on the estate planning side better than a lot of most firms. Well, better than a lot of most, but better than most firms. And that's because we have a certain expertise in that. And I think if you go and look at some attorneys' cards, right? I don't know how many people hand out business cards anymore, but my father, who was also an attorney, his business card said attorney and counselor, right? And it's something you'll find pretty regularly when you look back, especially at old business cards and signs for attorneys firms, because there is like a bifurcation in what we're doing. A lot of times I am acting as an attorney, which in and of itself is an agent, right? But a lot of times I'm counseling, right? We're talking about your life situation, and I'm able to use my perspective from having watched a lot of people do this and having interacted with the law and listening, right, is the biggest skill I have to have. I need to, as you can see during this podcast, I'm very comfortable talking, right? Sometimes I have to stop that and listen, right? And that's the most important thing, listen and pull that out. But then the next is trying to give that advice and counseling. And it's as big a part of our job as it is as doing the attorney stuff, right? And it's even more a part of estate planning. And so, the first thing I try to do is figure out where you're at and then try to understand your understanding of what we're talking about and then give you information that helps you educate yourself on what we're doing, right? And so getting back to our topic for today, powers of attorney. All right. What is a power of attorney? Right. And like I said earlier, it's an agency. You're going to name somebody that's going to act on your behalf. But where did this even come from? And I think it's an interesting story. Now, I have a history undergrad, so I may go a little long on this. But a power of attorney was something that was created out of necessity. Originally, before we had the internet, before we even had mass transportation, if you were in a place that was as vast as the United States, right? And let's go way back and go, wow, the United States was way bigger than Europe, right? So there's this huge swath of land, and you need to do a transaction, right? Let's say you're in New York and it's 18 whatever, and you're wanting to buy a piece of property out in the territories, right? Or you're trying to send somebody out to do a business deal on your behalf out in the territories. Your options for getting there are very slim, right? Walking, horseback, carriage, and train, right? Or ship, but you're even more limited based upon what the rivers are and all that. And so most of the time, people didn't go to do these deals. Sometimes they'd send, an emissary or somebody on their behalf. And that's what powers of attorney came out of. I'm going to do this deal in New Mexico. I'm in New York. Bob, you're going to go on my behalf. I'm going to sign this document and say that Bob can do anything I would do, okay? And then Bob's going to go to New Mexico. He's going to actually sign the purchase agreement as my agent and then come back, and then allows me to continue doing whatever I needed to do in New York and not take 2 weeks, 2 months out of my schedule just to go to do this one deal, right? Because you couldn't fax it either. Like all the things that start popping in your head, well, why didn't, oh, wait a minute. Yeah, I can't do that, right? And so that's where powers of attorney came from. Now, the power of attorney we use today is a little different because that one wasn't durable, okay? And you might have heard that attached to powers of attorney, well, a durable power of attorney. So those original powers of attorney, if that guy in New York, the principal, the person that wrote the power of attorney, became incapacitated, well, now it's no longer effective, right? Because Bob out there in New Mexico is really just an extension of the guy in New York. And if the guy in New York can't act, Bob can't either, okay? And so us creative attorneys said, hey, wait a minute. Can we write something into these documents where it says, regardless of my capacity, if I become incapacitated, as long as I'm alive, Bob can still act on my behalf, right? And so some wise attorney at some point invented that clause, and then those got used, and then this is when the estate planning attorneys come in and go, hey, wait, we've got something we could use that for, right? What if somebody can't act? Now we're going to take this power of attorney idea and flip it on its head and say, instead of they're acting on my behalf when I can't be there, they're acting on my behalf when I can't act, right? And I'm alive, but I can't do it. And so that's what this durable power of attorney that we use today. It's just a document that's in place where somebody can act on your behalf, and they can even act on your behalf when you can't act. So that's the basic background on the durable power of attorney. So what happens if you don't have one, right? If you've got an elderly person that can't act, or somebody that is going in for surgery, you need to act on their behalf, and something happens and now they're incapacitated for a long period of time. They're in a coma, or something's happened that's diminished their capacity. If you don't have a power of attorney, you're going to end up in court, because since we have no directions on who should act on your behalf, we've got to go to a judge. And a judge will appoint a conservator, all right, or a guardian, depending upon the situation. Conservator is for finances. Guardian is for your body or your health. Okay, we bifurcate that in these documents, and the court does as well. And so you'll go to a judge, you'll apply. People will step forward to be that conservator or guardian. They'll be interviewed by the court. The judge will look at their character, will look at all the facts, and decide who's going to act on their behalf. And then they're tethered to the court at that point, right? The conservatorship is created. That person acts on their behalf, but they're reporting back constantly. In the estate planning department, we don't want you going to court, okay? We're going to do everything we can to avoid that. And so what we've created here is these powers of attorney that will help you avoid that conservatorship, because you're going to be clear in this document about all the things the judge would have decided. Right? This is similar to the will, okay? Except the will is only effective when a court interprets it. I guess this is more like a trust, where it's effective the moment you sign it, okay? And so you're going to sign this power of attorney, and the first question is going to be who, right? Who should I name for this position? And then so the first thing you're going to think of is, who do I trust the most? And if we're talking about finances, the first question there's three factors that I talk about when we're picking agents for any document. The first one is age, okay? If you're going to name somebody that's older than you, there's more chance that your appointment's going to fail, because they're going to age quicker than you. They might become incapacitated before you do. And so picking folks older than you does not necessarily mean you shouldn't do it, but if you're going to do that, you should have a backup, right? The second factor is ability. Okay, if this person can't balance their own checkbook, I don't want them balancing yours. All right, and so that's the second factor. The third is geography, and similar to what we were talking about going back in history and appointing somebody to act on your behalf. Geography is becoming less of an issue as time goes on, because you can do so much online, but it's still a big factor when picking your agents, because being close makes things easier. Okay. And so when you're picking your agents, you look at those three factors, and then you say, okay, who's my number one that I'd like to be my power of attorney? And that'll be the person you pick as your successor.
When you mention a backup, how many layers of backup can you have?
That's a great question. And I tell people to flip their perspective on this. When we're planning, we're not saying what the future should be. Right? We're giving the future options, because the only thing that's for certain in life is change. And so when you're looking at the future and saying, who do I want to act on my behalf? Well, when you say this one person is going to act for me, you're making a lot of assumptions that they'll be around, that they'll have capacity, that'll make sense for them to act. And so when I tell people you're going to pick your agents and your successor, I say, look at it more of a draft. Here's my top 5, right? Here's the people that I would want to act at this time. And then I'm going to name 1, 2, 3, and 4 in that order. And then they can decide at that time, if number 1 isn't a good place to act, they can act. If they can't, they simply step aside, and the next person is activated, right? And that's the idea of having them in succession, okay? Because you could also name multiple people. And this happens a lot, where people come in and say, I've got 2 kids. I'd like them both to be power of attorney. And I think Joe and I talked about this in an episode about parents wanting to be fair, right? And they're not wanting somebody to feel left out, or like they chose somebody over them. But with a power of attorney, that could be a big mistake. Co-powers of attorney means co-acting, okay? And so anytime a document needs to be signed, needs 2 signatures, right? And
just in life in general, you always talk about how committees are rarely a good thing.
Right, right. No, there's an effectiveness, right, to having one person to make the decision. That doesn't mean that everybody can't discuss it, right? You just need a decision maker, right? Because, you talk about committees, one of the things that really holds committees back is they want unanimity, right? We want to all be on the same page. Well, the more people you get in the room, the less chance that's going to happen, right? And so you need somebody that's going to be able to be decisive and say, okay, I recognize your points of view, but I think the best course of action here is this, right? And that's why naming one and then another in succession. We'll talk a little different about this in healthcare, but with financial, I rarely recommend having co-agents. So you're going to name your top 1, 2, 3, 4 if you can. The more, the better. And then that gives the best chance of your plan working and the best person to act on your behalf being picked to act at the time that you need them the most. We've talked about who do I want to name? Well, the next question then is when would they act, right? And there's 2 different types of financial powers of attorney. The first is the power of attorney that we say is effective immediately. Okay. The moment you sign that document, that agent that's named in that number 1 role is going to have the ability to act on your behalf. Okay. And this is what we call a fiduciary relationship. You've been hearing that word get thrown around on financial advising commercials for a few years now, probably. What does it mean to be a fiduciary? It means that you need to act in the best interest of the person that appointed you, right? So in the power of attorney, the characters involved are the principal and the agent, okay? So if you're the agent, you've got to act in the best interest of the principal. Meaning I can't spend it on a new car for myself, right? Unless I'm driving you around in that new car.
Can't take a trip to Bangkok.
Can't take a trip to Bangkok without them, right? And so, and there's like everything else. We wish we were in a black and white world, but there's gray everywhere, right? And so what is in their best interest? Does it, because you get a benefit, does that mean it's not in their best interest? No, right? Things could be in their best interest and still benefit you. It's really when the tables change to it benefits you and not them that it becomes clear that you're breaching that fiduciary duty, right? And so when we're talking about the 2 types, there's the effective immediately, and then there's a springing power of attorney, okay? What is a springing power of attorney?
I immediately go, what does that refer to?
Right. Springing what? And so, like I said before, effective immediately means the moment you sign it, it's effective. That person named there can go act on your behalf. Springing means it only becomes effective upon a future occurrence, okay? And so what would that be? The most obvious is going to be healthcare. If you're not able to act because you're in the hospital, this person will act on your behalf. Well, how do they know? Well, it'll say in the document. Is it 2 physicians that have to say you're incapacitated, or 1, or is it back to a committee of individuals that get to determine it? You can decide that, but you want something in place so that it's clear when they can act, right? Another one is disappearance or jail. Okay, if you're not able to act and it's clear that you're imprisoned or you have disappeared for over 30 days and somebody can attest to that, then that person can act. Then the most obvious one, obviously, is the conservatorship. If a court has said you don't have the ability to act, then somebody can act on your behalf. And so that's the difference. Is it effective the moment I sign it, or is it effective upon some future occurrence? I would say the majority of the people that we work with choose the latter, right? They want a springing power of attorney. Hopefully you're coming to me and you're not in a situation where your capacity is in question at the time. And then it's like, why would I need somebody to make these decisions on my behalf? Or why would I even run the risk that they're going to do something that's not in my best interest? I'll make it so that they can't act until they absolutely need to.
Here's an interesting question. Let's say you have a family history of dementia. Could you put that in place knowing that this is entirely a likely situation for me?
You would definitely want to put that in place because this planning is trying to put a plan in place for an eventuality, right? Whether that seems likely or unlikely. And the more likely it is that something's going to happen, the more urgent it is that you need that planning. And so I would say, Yes, definitely. And you can even address specific situations in these documents for when they could be springing. As I've said in previous episodes, if you can think it up, I can write it, right? And it's very pressing in that situation. But, the other question is, what is capacity, right? What does it mean to be incapacitated? Again, like I said earlier about things being gray rather than black and white, with dementia, there's this thing called sunsetting, right? Where you can talk to somebody in the morning, they seem just fine, they could sign agreements, everything is clear to them. 5, 6 o'clock that day, totally different person, right? They don't remember talking to you that morning, they can't recognize their own family, and kind of like 51st dates, sometimes it can, change day to day, right? It's really hard on the individual, it's really hard on the family, but having a plan in place to take care of that is what's important about this power of attorney. And so incapacity is measured at the moment, right? If you can't act now, then that person can act on your behalf. So we've got these two options. Do you want to make it effective now, or do you want to make it effective upon some future occurrence? And as I've said, if you could think it up, we can write it. At Cordell, we've created another option, which is a certification that you can sign later, okay? So you come to me and say, John, I don't want this to be effective immediately, but I also don't want to be labeled incapacitated later, right? So if that document is a springing power of attorney, the only way it becomes effective is if you lose your right to act, okay? And again, gray, not black and white, there may be a situation where you're diminished but not incapacitated, right? And so say you're hospitalized or you're in a bed and you're recovering for a couple months from some large surgery or accident. You want this person to be able to act on your behalf, but you're not going to have that last forever. We're going to give you a document called a certification of authorization by principle. That's a mouthful, right? All it says is that if you sign it in front of a notary, that person that's named in the power of attorney that was previously a springing power of attorney is now effective immediately, okay? And so what we're looking at when we're looking at your planning is I want to put you in control all the time. All right. And if the only way for somebody else to act is for you to lose control, that might not be the best answer. Now, if you're truly incapacitated, that person needs to act on your behalf. But in many instances, it's not that clear. And so as people start to diminish, it's a great option to have the certification to say, okay, at the time I signed these documents with John, I was not ready for you to take over. But I am now, right? I need to go to the bank. I'm not going to get there easily. I'm going to sign the certification in front of a notary, which some of we can do online now. We're starting to move into that world. In September of 2025, the state of Missouri adopted RON statutes, okay? RON meaning remote online notarization, okay? And so we can do a lot of the same things that we used to do in person online now and create digital documents. It's really helpful for people that can't make it in. It's really helpful for people that aren't in St. Louis or any of the other major cities that we're in right now. If you're in an outlying area and it's too much of a burden to get into the office, if you're in one of these states, which right now the only ones we service that have RON is Missouri and Illinois, we can take care of you anywhere in that jurisdiction.
So kind of along those lines, I have a more practical question.
Yeah.
So let's say you have a parent that they get into a situation where they're hospitalized and maybe their credit card is due tomorrow and you need to immediately take care of that. What is the exact steps that they take? Do they call you and say, hey, this happened, can we take care of this?
Mm-hmm.
What would those steps be?
Well, this is where we get into something I call practicality versus legality, okay? So legally, in order to make a decision on somebody's behalf, you need to have these documents in place, okay? Practically, some of this stuff can be handled online with usernames and passwords, okay? And so when we're talking about the need to act immediately, in order to truly act on somebody's behalf legally, some document like this needs to be in place where that agency relationship is created. But there's a lot of practical ways to put plans in place that aren't necessarily revolving around documents, right? Just having a document in your desk, or I'm going to tell you, 95% of people keep most of their passwords in the notes on their phone. Okay. And so if there's somebody in your family that you trust, right? All these roles require somebody you trust, right? But if there is somebody you trust, which I'm hoping there is, you can tell that person, hey, here's my iPhone has all of my passwords in it. Here's the code to my iPhone. Okay. Sometimes they need to know how to get into your email as well because of two-factor authentication. But that person could step in and do a couple small things before they even have to present anything anywhere, right? What we're really talking about with the power of attorney is where you're up against somebody at the custodian, right? Like if you're at the bank and you're at the teller and you're saying, I need to get this money out. Well, we need proof of your ability to act, right? That's when the power of attorney is going to be the most important, is when you need to prove that you have the ability to act on somebody. Because, I can say to you, hey, Justin, will you go grab me a drink, right? That's an agency I just created right there. I asked you to go get something for me, okay? Now, I don't need a formal document to do that. But if he gets over to the refrigerator and there's somebody standing there guarding it, and he says, I'm getting this drink for John, and he says, well, how do I know that you're getting this drink for John and not for yourself? Probably need something in place to prove that, right? So that's where these documents become necessary, is when there is somebody that's kind of guarding the vault, right? And you got to say, hey, I can pass. Here's my ticket. It's the power of attorney, right? And so when we're where do these documents come from, okay? They're very state dependent. Like a lot of the things we talk about in Life's Third Act related to estate planning, what state you live in could dictate what your document looks like. So first of all, some states have what we call statutory powers of attorney, which means that the whole document is spelled out in the statute. The legislature determined, hey, we're going to make this as clean as possible. We're going to give people what it should say. So then there's less questions, which is always helpful, right? Clarity. And so some states have statutory powers of attorney. Some states have statutory healthcare powers of attorney, but not financial, and some have both. So that's the first place to start. Does my state have a statutory power of attorney? If not, you're going to have to create one, okay? And they're not as consistent as you may think they'd be. The lawyers aren't all taking this from the same book, right? It's not like there's some subscription that we're the only ones that are able to get, okay? We've worked on these documents. We've worked through experiences with people. I'd say that annually I'm reviewing them and thinking, okay, has anything changed? What situations have I run into, right? So a great instance is safe deposit boxes. My powers of attorney used to not say anything about safe deposit boxes. And then I realized, oh, wait a minute. If I can put this in here, that's one less thing that people can get tripped up on. And that's a lot of, sometimes people say to me, the power of attorney, the financial power of attorney could be a 30-page document. Okay. Why do I need this? Is this really necessary? And the reason the documents get so long is because of those specific situations. All right. And so when we're talking about a document and an agency, when I write that document, I'm saying in that everything that the agent can do on my behalf. If there's something if a question arises and the document doesn't answer it, what do you do? Right? If I'm at the bank and they say, well, can he do this? And they look at the power of attorney and it's not clear, where do we end up? Well, we end up in the same place we would have been without the power of attorney. We've got to go to a third party to figure out what that person's authority is. And a lot of times that's a court. And so the reason our documents are long is because we're clear about your authority in relation to every type of asset you could own. It may be things you've never thought about owning, mineral rights, right? Businesses, LLCs, S-corps, all these things that you'll see in our documents and go, John, I don't have any of those things. And I say, you don't today. But again, we don't know what the future holds, right? And maybe there's a 95% chance you'll never be involved in a business. That's great. There's no harm in having it in there. There is harm in not having it in there. And so when we write these documents, we try to think about every situation that can come up and we address them in there. And that's how they become so long. And so that's the specific powers section. And there's also stuff in there that state laws require, okay? State legislatures have realized this is a really powerful document. Even some states, you look at their statutory forms and there's like a 3 or 4 page thing in the front that says, hey, this is a very important document. Somebody's going to be able to act on your behalf and do things as if they were you, okay? Before you sign this, think about that. Is this something you really want to do? And before you pick someone, think about that. Want to make sure they're the right person. And so states try to be clear on this because a lot of problems come out of powers of attorney when somebody doesn't act on your behalf. And so there's certain powers that are so important, like, can this person change the name on my checking account? Ooh, I don't know if you'd want them to do that, right? Can this person gift my property to other people, right? Because they're acting as if it's their property, now for your best interest, but you could tell them, yes, I want you to be able to gift stuff. Well, wait, John, why would I want anybody to give away my property? Well, what if you give regularly to your church? What if you have regular charitable contributions? What if you take care of a dependent, okay, and you regularly give them money? What if you've got a situation where, for tax purposes, you're doing regular gifting to your family? These are things that are very case-specific, and so what we'll do at Cordell is we'll sit down with you and walk through the power of attorney, okay? You're not going to come here and I'm going to ask you a few questions, then you're going to sign a 30-page document that you don't know what it says. We're going to meet in my office, and I'm going to put it up on the TV, and I'm going to walk through the different terms, and we're going to talk about what it means and whether you want it or not, right? All your decision in the end, and then you'll get to see, oh, okay, well, maybe I do want this person to be able to do that, but maybe I don't want them to be able to change the terms of my trust, okay? We'll take that out, right? But that's very state-specific as to what needs to be written in there, and it's very person-specific, and it's very individual specific to determine what makes the most sense for you in your situation. The last thing I'll talk about in relation to powers of attorney is using them, right? Because we said there's two main characters here. There's the principal, the person that created the power of attorney, and the agent, or the power of attorney in fact, whatever you want to call it. When that person uses it, they need to be careful, okay? Because they have to do everything in the best interest of the principal. And they can make mistakes. And a lot of times they don't even mean to do it. It's like, what would that be? Well, I was talking a moment ago about checking accounts, right? Putting names on them. If you have a joint checking account, which a lot of people do, right? I've said before that titling is one of the most important things in estate planning. And one way that you can do estate planning without coming to me is by having joint ownership on an account, okay? But what most people don't understand about joint ownership, if I put a friend on that account, right? Let's say I'm not married, although I am, she's wonderful. I put a friend on my checking account just in case, right? This happens a lot as people get older, you know. They're a single individual. They say, I'm going to put my daughter on my checking account. That way, if something comes up, she can write checks, she can go to the bank, she can do everything, right? That is correct. You know what else she can do? Withdraw 100% of the funds with no recourse, okay? Because you just made her an owner of that account, right? Not a beneficiary, not somebody that can act on your behalf. You made your property her property, which you essentially gifted it. And people don't think about that when they sign these powers of attorney, right? And so if I say, I'm going to make my daughter my power of attorney in case anything comes up, smart decision, but you've already made her a joint owner on the account, all right? And so all of a sudden a check comes and it's in your name and it needs to be deposited somewhere. She deposits it in that joint checking account. Under the law, she just stole your money. She didn't mean to, right? She's putting it in the account with your name on it, but the account also has her name on it. So the money that should have been yours is now both of yours. And under the power of attorney, she was supposed to only do things in your interest, okay? If she withdraws that money, she's just converted it, okay? And these are the kind of things we talk about, the practicalities. We're going to talk about this in the meeting, and I'm going to ask you, all right, do you have any joint checking accounts with this person? Well, maybe we don't want to do a power of attorney in this situation. Or more likely, I'll say, let's change that account. Let's remove that person, and let's make them either a beneficiary or, better yet, you've got a better option now. Let's have them act through the power of attorney, okay? So that's one of the considerations that an agent might want to think about. The other one is just making sure that everything is in that person's best interest, okay? And making sure they have access to the information. You put this document together. I'd say one of the hardest things for agents is that what you're essentially doing is stepping into the shoes of someone else, right? But you're just there that day. You haven't been there the months, years before where all the decisions were made that led to the ownership and all the things that they have at that point. And so there needs to be a certain level of education for that agent. They need to have access to statements, to accounts, to know what your intent was when you did these things. And the more you can inform them, the better job they're going to do. Hopefully this episode on financial powers of attorney has been helpful for you. Follow us next week on Life's Third Act to learn more about healthcare powers of attorney, living wills, and healthcare directives. We'd appreciate it if you have any questions, drop it in the comments. We'd love to hear your feedback, and we love to hear topics that you'd like us to address in the future. Also, for a limited time, we're running a deal. If you reach out to Cordell to do your estate planning and you mention Life's Third Act, we'll give you 15% off any package or document.
We hope you enjoyed Life's Third Act, sponsored by Cordell & Cordell, your advisors for estate planning and beyond. Subscribe and join us weekly for thought-provoking discussion and topics exclusively focused on estate planning and your financial future. Discover more at CordellCordell.com. The choice of a lawyer is an important decision and should not be based solely on advertisements.